Good morning and welcome back. I trust by now you've all had an opportunity to go through the slides, listen to the audio, do the readings, and attempt the homework or tutorial question. Okay, so what we're looking at today and what we've looked at, what you ought to have been looking at over the last week, was the question of jurisdiction, or the issue rather of jurisdiction. Why is jurisdiction important? I mean, I know you did it in first year and you probably thought that was where it would end. But why is jurisdiction important in criminal matters particularly? You can raise your hand and unmute yourself. Why do you think jurisdiction is important?
Ms. Boundary, can I answer?
Go ahead.
I'm just going to apply, like when you say jurisdiction, I always think of like international law. And it's like jurisdiction is important to know, important so that you kind of know what law applies there and who has the authority over that case or dispute.
Okay, but from a local perspective in South Africa, where we don't have a federal government, we don't have federal provinces, we've got provinces, but largely the criminal law that applies in one province is exactly the same that applies in another, right? Same is true for the type of sentencing and which court or courts have jurisdiction in that perspective of sentencing. So from a local, if we were going to translate what you said in relation to international law, jurisdiction from a criminal law perspective at local or national level is important because it tells you which court, based on various factors, based on the nature of the offense, based on where the offense occurred, based on the seriousness of the offense. In other words, what the likely outcome, if there was going to be a guilty verdict, what's the likelihood of getting a very harsh sentence versus a more lenient sentence, or a fine, for example. So all of those factors are what determine which court will have jurisdiction. And so we got to think about jurisdiction not only as far as geographical jurisdiction is concerned, so which province, which district, or which region, for example, the offense occurred, but we also have to think about it in terms of if it occurred in a particular province, in that province, is this a matter that must be heard and deliberated over at the High Court or at the magistrates court level? So and why this is important also is because when we get to the section on pleadings much later, you know that when someone is asked to plead, an accused person can plead guilty or not guilty, but there are actually very many more pleadings that this accused person can raise. So guilty and not guilty aren't the only options that the court can hear. One of those pleadings would be that this court does not have jurisdiction. In other words, the prosecutor is the wrong prosecutor. It ought to have been heard in some other court, but definitely not this one. And that's another reason. To from the perspective of a prosecutor, a public prosecutor who is acting on behalf of the state, it's important that he institutes action out of the right court, because obviously when the accused person comes to court and then pleads, well, you've got no jurisdiction, right, geographically or otherwise, depending on what the facts of his plea are, it serves as a delay in delaying. So you've got the magistrate or the judge who's prepared to start. You've got the prosecutor who's prepared to start. You've incurred costs of legal counsel for the defendant. But now the matter, everyone's present, but the matter can't actually go ahead because of lack of jurisdiction. Okay, So yeah, we also then moving on from there or building up on that is that we see that there are various courts. So forget geographical jurisdiction. Various courts have the power, the jurisdiction to hear particular types of matters. So that's also important for us to know. Now, if we wanted to bring a practical example of how the courts work together and how jurisdiction can be transferred from one court to another, if we look at the murder trial of the death of Riva Steenkamp, the Pistorius trial was the most, televised and first of its time televised in South Africa, and we saw that the initial parts. So when we talk about the criminal procedure system, we also need to talk about pre-trial, bail situations, bail applications, etc. And that stuff started out in the magistrate's court, but was then transferred because of the various factors, the nature of the offense, the seriousness of the offense, etc. The type of sentence that could emanate from there. Um, and we'll see when we talk next week about the powers of the director of public prosecutions to, despite all of these factors, still make a decision to move a trial to another court. Okay, so other factors like how much interest this matter has, likelihood that the matter being heard in one court over another court causing disruption civilly or in the state, in the community, whatever. Those other factors may necessitate moving the matter to um, to another court, to a higher court, if that may in fact be the case, right? So there's a number of factors. We run through the slides and we consider the various courts, talk to you about the Constitutional Court. Please, whoever's unmuted, please mute yourself. The Constitutional Court, okay, and what types of matters are heard in the Constitutional Court, the number of judges that sit, etc. We also look at the superior courts, and that includes both the Supreme Court of Appeal and the High Court, and we break those down into which are the provincial divisions and which are not provincial or local divisions. And why that's important is because if a matter is heard in a local division, it can go on appeal to another high court, albeit a high court, but of the provincial division with a sitting of more judges. So we see why that also is important. Now, much of your work when you start practicing, when you're in articles, you're going to have rights of appearance in the magistrate's court only. Okay, when you start, when you become a second year clerk, then you still won't have rights of appearance in the high court, but you'll be able to appear not just in district matters, but then in regional matters. And you'll start, if that's the type of practice you're in, you'll start seeing more high profile or more serious criminal matters, if you're lucky enough. So the lower courts are pretty much, we're talking about the magistrates court, and that's broken down into regional courts and district courts, and beyond that periodical courts. And periodical courts are more in the sense of traveling courts that move, the seat moves from region to region depending where the area is too remote and may not justify parties themselves coming into the city center for particular matters. So that does exist as well. Now, jurisdiction regarding criminal courts, we need to look at what types of criminal matters can be heard, regardless of whether the matter is in the High Court or the Magistrates Court. So we in these slides we look at, well, at appellate level, the Supreme Court of Appeal. Can the Supreme Court of Appeal act as a court of first instance when it comes to criminal matters? And the answer is no. It's usually only matters on appeal. So matters emanating from one of the lower courts or the High Court, for example, that are being taken on appeal to a full bench of the Supreme Court of Appeal. And we talk about the nature of the offenses from each of these different courts. All right, so we have spoken about that. No need to discuss it again. Yeah, what I want us to get onto though is this issue here. And that's the also part and parcel of the tutorial question that you're meant to have been discussing. So I trust that you've read De Beer versus the state. Okay. We need to talk about geographical location, geographical jurisdiction. Now, the way in which the jurisdiction, if you're talking about geography and territory, works in the magistrate's court is that the seat of the court only has jurisdiction in relation to matters that happen within its district or within its region. Okay, but depending on the and we see then that can have um, some difficulties and some negativities, considering that districts are smaller than provinces, right? And so we look at an extension or an exception, rather, to the rule concerning territorial jurisdiction in lower courts. And that exception is contained in the Magistrates Court Act, known as the 4 kilometer rule. And the 4 kilometer rule has with it various rules or requirements that apply um, to determine whether or not a matter that occurred outside of the territorial, the strictly territorial or jurisdictional, geographical jurisdiction of a particular court, even though it happened outside of that, whether a court can legitimately assume jurisdiction over that matter. Now, how the 4 kilometer rule works, like I said, it applies to magistrates' courts. But when you look at the rules in your notes and what we've said in the audio, it makes an example of vessels, conveyances, as in motor vehicles. It talks about, and a good example to look at is the crime of theft, which is a continuing crime. And you could think of it if the offense began somewhere. So the object was stolen in District A, put in a car, driven through District B, driven through District C, and eventually apprehended and caught with the stolen merchandise in District D. The question is, which of those courts would have jurisdiction? Difficult to determine. Now, the simple answer, the knee-jerk reaction is that, well, the the jurisdiction would be in the place where the offense occurred. But the nature of the offense, theft, is a continuing crime, means it doesn't actually come to an end. So any of those, strictly speaking, any of those districts or areas would have or could have jurisdiction. Now, the Magistrates Court Act allows for one court to assume jurisdiction in these matters, and that could be either through the working of the Director of Public Prosecutions, right, through the NPA to say, well, okay, fine, it's complicated, let's just have it in one particular court. Or alternatively, by application of the 4 kilometer rule, that if a matter, if a crime occurs or is apprehended, let's say, within 4 kilometers of the boundary of another district, either of those courts could have jurisdiction. Okay, so I don't know if I'm making myself clear. Did you understand what I'm saying regarding the 4 kilometer rule?
Mm,
So let's draw some fictional districts. Sorry. So you've got District A and you've got District B, right? You've got two districts. A crime occurs here. People are apprehended here. And from the boundary of A to the boundary of B, the 4 kilometer rules applies to say that if that happens within 4 kilometers of the boundary of the one district, that court can assume jurisdiction. And that is how it would work. Obviously, there are many other factors that come into play, and look at the notes, listen to the notes, the audio and the slides in relation to how the 4 kilometer rule would apply in assuming jurisdiction. But a handy example is that one about, you know, what was I saying? About theft being a continuing offense. Okay. And also in relation to the nature of offense, or if the offense is particularly complex. So if you've got a situation where it was a robbery and with theft and a motor vehicle is stolen, and through the traveling or before apprehension, before these accused persons, these suspects could be caught, they commit several other offenses throughout the districts or territories in which they are traveling. How then would you get jurisdiction? Would it be convenient, reasonably, would it be convenient to say for each of those offenses, it must be tried in a different court? And so the accused parties are moving from court to court, from district to district. Now, that could be very inconvenient, right? It could also work out to be a time wasting exercise. And so the court could assume jurisdiction, one court could assume jurisdiction in terms of the 4 kilometer rule and say, no, because it is part and parcel of one event and all of the other factors that go into that, this one court is going to hear or have jurisdiction over this matter, right? Okay, so do you understand what's going on there? So that can take us into, not going to worry about punishment too much right now, because we'll deal with that later, and you'll deal with punishment and sentencing when you get to, if you decide to do sentencing as an elective. So this is a question, and this has come up as a question in a previous exam paper. Can a high court assume jurisdiction over criminal offenses committed beyond its territorial limits? Does the 4 kilometer rule apply? How did you approach this? So what type of question is this? What type of question is this? How did you approach it? What was your format? Is it a problem type question? Sfiso, go ahead.
Hi, Miss B.
Hi there.
My apologies for not changing my name. That's my other name,
Oh, it's your
Sfiso.
other name. All right, Tabo. Okay. What type of question is this?
How I approach this question, I mainly explained the PS case
No, I'm
and
asking
I
the first question I'm asking you is what type of question is this? Is it a problem type question or is it an essay?
it's an essay type question.
It's an essay. What
Yes.
type of essay?
I don't know how to answer that, but I think it's
Okay.
mainly explaining how the court
Okay, so this
interprets.
one asks you to analyze
Yeah.
judgments to see how the court applied a rule, right?
Yes.
Now, once you're able to work that out, you are then better able to work out what the achievables in your essay must be,
Mm.
right? You're also further required to express an opinion or give a legal answer to the question. What is the question that you're meant to be answering? Even if you weren't told which case to look at, what is
Yes.
the legal question you are specifically asked to answer?
Mm. So really, let me just do that. Okay. So I think the issue we're dealing with here really is whether the High Court has jurisdiction to try offenses allegedly committed within the area of jurisdiction of another High Court. So specifically dealing with the application of the 4 kilometer rule.
Simplify that, because most of that was just telling me my question.
Okay.
I need to
Okay.
see that you
Yeah.
understanding, because that informs what you write.
Mm, mm. I think mainly is whether the 4 kilometer rule can be bypassed or it is strictly or maybe required to be strictly applied.
No, let me help you.
Okay.
Does the 4 kilometer rule apply So, does the 4 kilometer rule apply only to the magistrate's court? Or can the High Court use the 4 kilometer rule to assume jurisdiction in those circumstances?
Oh
Now,
wow.
and that,
Oh,
and
sorry,
that,
you can continue.
yeah, because that essentially is what the court in De Beer had to decide. Yes, there is such a thing as a 4 kilometer rule, and it's contained in an act.
Mm,
It's contained in the Magistrates Court Act. And here, Director of Public Prosecution is saying, yeah, no, we're
yeah.
using the 4 kilometer rule and we're taking jurisdiction. But the other party raises what? Remember we said that you can raise as one of your pleadings lack of jurisdiction? So they raise lack of
Yes.
jurisdiction, saying this is the wrong court. You cannot use the 4 kilometer rule. And the state says, no, but the 4 kilometer rule exists. So the court says, well, yeah, it does exist. It does exist. But who does it exist for? When can it be used? By whom can it be used? So that's the question. That's the question that very simply was the issue before the court in De Beer. All
Mm,
right, so the trial for whatever the actual crime was hasn't even started. This is a trial just to determine whether are we in the right court.
yeah. Yeah.
All right, okay, excellent. All right, now tell me how you dealt with that.
Mm, no,
Anyone.
Miss Blue.
It doesn't only have to be Tabo.
Oh, okay. I just give others a chance.
It's always easier to answer the first question. The second question now, how did you deal with it? Knowing that, now I'm sure what we've just discussed helps you focus what the point of what you're trying to say is. What is the methodology? So if you were using IRAC, then you can absolutely use IRAC. What would your answer be dealing with? I don't need to have the answer. I just need to be able to hear that you can identify the things that you need to make sure you speak about? So you are, in fact, it would be a good idea to use FIRE Act. Can you all see that, right? But the way in which you go about it may mean that you've got to change things around. So you'll start with I, right? You'll identify the issue, which we've just done. Logically, you'd then go into, you could go into R. No, let's go into F. You'd go into F and you'd give a brief summary of the factual matrix of that case of De Beer, and get to the point of saying the court had to decide. Now you get to rule of law. So what does the law tell us about the 4-kilometer rule? Now logic would dictate that you describe and explain what the 4-kilometer rule is. So what is it? Where is it found? Which act? What is its purpose? And how does it help? What is its purpose? What is it meant to achieve, right? You then go back to not the facts of De Beer, but the reasoning and argument heard by the court in relation to the 4-kilometer rule, right? In other words, this is where you're analyzing. You're not applying. In this scenario, it's not applying, you're analyzing what the court in De Beer, why it decided what it did. What was its reasoning, the ratio? And it comes from looking at the facts, looking at the judgment, and seeing where that is. And so then you get to your conclusion. Your conclusion would be, well, the 4-kilometer rule exists, but only for magistrates' courts only, and the court offered the following reasons regarding confusion and territorial issues, etc. So that is how you would deal with a question phrased that way. What did you use a different method, a methodology? How did you approach it? Nena, it's not a problem question. It's an essay question. All right. What was your method? Okay, so if we're preparing for exams and the final assessment, you'd need to be familiar with the 4-kilometer rule, how it applies theoretically. I won't put up a problem question to say that a crime occurred here, there, everywhere, and expect you to sit with in the sense that I'd expect you to sit with a map of the districts and work out whether it's within 4 kilometers. But the same question could take on another dimension. So not necessarily where you analyze a case, but one where there's no direct requirement to analyze a case, rather just to discuss the 4 kilometer rule in a general fashion. But that still will require that you refer to case law that has had to deal with the question of the 4 kilometer rule as a jurisdictional conundrum. Okay, Tabo?
I mistake. Where I think where my mistake was. I think I forgot about the magistrate court and only focused on the high court. But in approaching the question, I firstly looked at the brief facts of the case, the De Beers case, and then I looked at the issues that were brought forward, and then the outcome of the court, and ultimately the reasons for that outcome. I don't know if it's important to also mention the exceptions in applying the 4 kilometer rule, whereby we take into account the victims or the family of the victims involved.
No, that
And
certainly does, because but that comes into when you're talking about generally when you would consider the 4 kilometer. Now that bit about the victims, the director of public prosecutions was using to say, well, here's legitimate reasons for us to move the the geographical jurisdiction to this particular court, and we are further relying on the 4 kilometer rule. Now, the National Director of Public Prosecutions is the only one pretty much who can sign off and say, look, your reasons are valid, because we know now that the 4 kilometer rule cannot be used by the High Court to assume jurisdiction. So all of these other things is what the public prosecutor, the deputy director of public prosecutor was saying, well, these are legitimate reasons why we are applying to have jurisdiction moved. Now, those reasons alone weren't enough to sway the director of public prosecutions to say, okay, another court can hear this matter. And we will talk about the role of the public prosecutor and the director of public prosecutors in this sense in next week's lectures. But it is only when in a high court matter, when the director of public prosecution makes that declaration that a different high court can take jurisdiction, right? Now, in this case, the director of public prosecutions did not sign off and said, no, we are not moving the court. Despite that, the deputy director of public prosecutions said, well, we're still just having it in a different court.
Yeah, I know.
Later, when the matter does start up, the defense says, but this court doesn't have jurisdiction to hear the matter. The 4 kilometer rule doesn't apply, number one. Number two, the director of public prosecutions declined to extend jurisdiction or give another court jurisdiction in this matter. So that part for this question is useful, but will not actually answer the question being, can the High Court rely on the 4 kilometer rule? It would go towards a similar question, but phrased differently. In other words, with a different issue or a different area for you to discuss. For example, that question would be, is it legitimate, right? Or what are the circumstances under which one high court can assume jurisdiction over a matter that is outside of its jurisdiction? And there you'd be looking specifically at the powers of the Director of Public Prosecutions and the NPA in that regard.
Yes.
So if we were to take this same question, right, and we remove this, can a high court assume jurisdiction over criminal offenses committed beyond its territorial limits? The short answer would be yes. Yes.
Yeah.
If the National Director of Public Prosecutions gives you a written notification that this can be done. And these are the factors that would be taken into consideration. But because the question is specifically asking you to look at a particular rule, a rule that comes from where? A rule that comes from where? That's the wrong color. Right? Forces you to look at the difference between the jurisdiction of the High Court and the Magistrates Court, and whether the rules that come out of the Magistrates Court Act
Yeah.
apply equally to the High Court or not.
So it's more like a contradiction, or no, I mean, it's more like a just a position between the two courts, the magistrate and the High Court.
Well, it's because they are, yes, exactly. What are the, jurisdictionally, what can be done in the High Court? Jurisdictionally, what can be done in the Magistrates Court, right?
Yeah.
But we also know that for both courts, there are rules that allow for one court to take over jurisdiction or take over a matter from another court, and that could be nature of offense, type of punishment, circumstances of the victim, circumstances of the accused, what is convenient, how complicated the matter is, how many accused persons there are, right? But here you're specifically asked to, well, let's look at the rules here. Let's look at the rules that apply to the Magistrates Court. Let's look at the rules that apply to the High Court. And do they apply interchangeably?
Yeah,
What sport do you play, Tabo?
Sports.
Yeah.
I'm interested in weird things, but sports, not specifically like the sports where you use your body. I enjoy motorsports, just watching motorsports. But I understand rugby a bit.
Okay,
Not
motorsport. Okay, rugby, right? Rugby, right? There's different formats for rugby, right? You can get maybe a five-a-side game, and then you get a full, I don't know, what is the full complement of a rugby team, right? It doesn't mean that because one match is being played and another match is being played, that they're playing different games. They're still playing rugby, right?
Yeah.
But the rules that apply to this five-a-side game and the rules that apply to, let's say, a World Cup match are different. And so when something happens in this World Cup match, can they apply a rule that exists for the five-a-side game but does not exist for the Rugby World Cup tournament?
Oh wow, that makes sense.
If you're looking at what you said, motor racing, right? You get different types of racing. There's Formula One, there's NASCAR, whatever, but it's all still driving, it's all still racing. But the rules for Formula One are different from the rules for NASCAR.
Yes, very much.
Nothing about those two things say that they are not criminal trials, they are not racing, motor racing, correct?
Yeah, in essence, it's racing.
But the rules that apply for NASCAR aren't the rules that apply, and there's good reason why.
Yeah.
So what is the good reason why? Although there's a criminal match happening in the Magistrates Court and there's a criminal match happening in the High Court, what are the good reasons why there are different rules here and different rules there, and they don't overlap? There may be some overlap, but they don't overlap.
I understand it much better now. I think, yeah, paying careful attention to the wording, I think it plays a huge role, because I looked at it as if maybe it was a question of whether the 4-kilometer rule applies to the High Court, not looking at it in the Magistrate Court and the High Court and just opposing the two.
Yeah, so that's how you ought to. And like I said, from the very start of this year, when I started lecturing to you guys, the words that you have and the words you've been given and the words you can use at your disposal are so very important, right? I said this before and I'll say it again. Words is what make us as lawyers. Words can make or break your case. And we will spend days, weeks, pages of a judgment arguing over what a particular word means. What happens if the comma were to move? Why is the comma here? And what does the comma mean for the rest of the sentence here? And if that comma was gone, what would it mean? So your very first thing is to, well, have I understood the question properly? And it's only if you know what the question is wanting you to answer, can you properly identify the issue. And if you properly identify the issue, then only can you effectively deal with all the tick boxes that you're meant to be dealing with.
Mm, mm. No, it makes a lot of sense. Thank you so much, Ms. P. Thank you so
I have
much.
my
I understand.
moments. I have my moments. All right. Any other questions? Any other questions? But you see then how to extract. You had and you know, even if I just said to you, discuss the De Beer versus the state case, you should have done exactly the same thing.
Mm,
Even if I did not put it into context, you ought to be able to work out, well, what was the problem? Why was this matter at court? And
yeah.
why was it a type of judgment? It's just jurisdiction, man. Why is this judgment so important that it was reported? What is so important, so technical, that makes this judgment on something as simple as jurisdiction reported and reportable?
Mm,
Because you'll come across a lot of judgments unreported, unreported, because it may not be changing the law or giving definitive answers. It's available for research and it's available to be, but it's not important enough that it goes in a bound version. Now we're seeing fewer and fewer unreported judgments because thanks to electronic media and being able to upload judgments without worrying about what paper costs and what ink costs, right? But before the technological advancement, a judgment had to be worthy of being reported formally and making it into a law report, a set of reports. So that's another thing that you'd be thinking about.
mm, mm.
Okay, anything else, guys? MP, you have a lovely voice. Or whoever was singing. Yeah, so as far as next week is concerned, then please, I hope you are still continuing and making progress effectively as far as your assignment, assessment 1 is concerned. The readings are there available for you. So you should be casting your mind. And again, let's just look at that. Let me just open up Moodle. Yeah. And you need to ensure that you actually understand the question. Okay. Understand the question. What is What am I supposed to be giving an answer on? What am I supposed to be expressing an opinion on? Right? And you can't, and you saw this with the first assessment, and you saw this with the assessment 2, the portfolio, that if you weren't effectively able to work out what this question wants from me, you're not able to deal with the issue. You're not, and like we've already worked out, the issue isn't rewriting the question or rewriting the catchphrase in the question. So again here with this one, what am I meant to express an opinion on? How can I say that I have informed the reader or the querent or my client about what it is that they actually want? And like I said to you before, that you're going to have a client who is not a lawyer, right? You're going to have a client who is not a lawyer, who will come to you with all of these long stories, hours of consultation, and say to you, hey, you know what, I think my problem is, I think my issue is. But you are trained otherwise. So when you go to a doctor and you tell your doctor all your symptoms and you say, hey, you know what, I think I got flu, does the doctor just say, oh, okay, good, it's a 2-minute consultation, patient says they got flu, writes up flu meds? No, the doctor says, no, hold on, let me listen to your story, tell me what's going on. Listening to all the symptoms, the story, whatever, the heavy drinking the night before, etc., Then the doctor says, no, 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 your issue is not flu. Your issue is you're hungover, right? Exactly the same. A question will be posed to you by me, by any other examiner, right? There are red herrings there. There are things that are important. There are things meant just there for information purposes to give context to what you're meant to answer. But clinging onto a keyword, and worse, clinging onto the wrong keyword, will result in 2,000 or 3,000 words of something that, although is not wrong, is not right. Do you understand what I'm saying? So although everything that you've put down in terms of law generally is correct, it's not right to solicit marks because you've not actually answered the question. So I do often say to students, you weren't wrong, you were just not right. Okay. So please, please effectively work through that stuff. Do those readings. By all means, use outside sources. Please show that you can research. And the for next week, I will put up. I will now at the end of this lecture make this visible to you. So the stuff that you need to read, the tutorial questions you need to work on, etc. for next week's class. Let me do that now. Okay. Any other questions? All right. So yes, again, like I said, with the recordings, I am recording them, but I explained to you that my computer is pretty much on its last legs. So as I am able to, and if it allows me to upload it, I will upload the recording. But you know, obviously, that it is best to be in the session because then, you know, it's best for everybody if you are. But I will do my best to upload the recording to the channel. All right, so thanks everybody for listening. And again, don't forget to carry on with, you know, make progress with the assessment. You know, you've got it in advance. Do not leave it till the last minute. You know, prepare and work towards our discussion for next week so that we can again have an informed decision and informed, lively discussion. Okay, thanks everybody.